All right, we'll get started here. Welcome to our inaugural, first of its kind, Constitution Day mock convention. The Department of Political Science and Geography is excited to host what promises to be a doubly exciting event today. Not only do we get to learn more about a very important but complicated aspect of the US political system, changing the Constitution, we get to participate in and exercise our powers as active, deliberating, and voting members of this democracy, which is a pretty good deal for a Wednesday afternoon. The matter that brought us here is, as I'm sure you know already, relates to the organization and operation of the US Supreme Court. In its current form, Article 3, Section 1 of the US Constitution stipulates that justices of the Supreme Court shall hold their offices during good behavior, which has been interpreted to mean they hold these offices for life until retirement or until removed through the impeachment process, or death, I suppose. An amendment has been proposed here to introduce term limits, and you will hear arguments for and against said amendments. You are sent here as delegates by your state, but should consider yourself voting as individuals. Listen to both sides of the argument, follow your conscience, your principles, and cast your vote at the end of this process. Here's the outline for the event. We'll begin with a brief overview of the amendment process. We will then introduce the amendment text and hear arguments for and against the amendments. We will then open the floor for questions and comments from the delegates, that is you. Once that is concluded, we will move into the voting procedure. I believe we have determined that a simple majority vote will send this amendment to the states for ratification. Is that correct? All right, so a simple majority is what we're shooting for here. And I'll hand it over to Dr. Almeida to talk a little bit about the amendment process.
Thank you, Dr. Lemke. Colleagues and friends, honored delegates, welcome. You today are part of history. Nobody has been asked to do what you are being asked to do today. There have been dozens of state constitutional conventions throughout our history, but never one to amend the U.S. Constitution. So before we get started, talk a little bit about why we might choose to amend the Constitution. After all, we all know it was written by human beings who are the most moral, wisest, and most forethoughtful individuals who have ever walked the earth, hands down, bar none. Nevertheless, the Constitution is foundational, but it is not frozen. Article 5 specifically provides mechanisms where future generations of Americans can change the Constitution to adapt it to their own needs, to the needs of the time. We have done so, for example, to guarantee the right to vote for women in 1920, and then to extend the right to vote to Americans 18, 19, and 20 in 1974. The process is not easy, and it shouldn't be, but it's also not impossible. There are two ways to amend the Constitution. An amendment can begin in Congress, where it needs to receive a vote of 2/3 of the House and 2/3 of the Senate, or it can be done this way, through an Article 5 constitutional convention. 2/3 of the states have asked Congress to convene a convention whose purpose is to amend the Constitution, and that is why we are here today. Both of those mechanisms, through Congress and through a convention, can only propose an amendment. To ratify an amendment requires the states, 38 of them, as a matter of fact, 75%. That can be done either by the state legislatures, which has been done for 26 of the 27 amendments, or by conventions held in each of the states, as happened during the 21st Amendment, the Prohibition Amendment. The process is hard, and that is by design. The high threshold represents the intent of the framers. Right? Only amendments that have broad support have a chance to succeed. And I don't mean bipartisan support, or at least I don't just mean bipartisan support. 75% of the states mean geographic consensus, demographic consensus, economic consensus. There aren't enough there isn't any one demographic, economic, regional, or political party that can summon the support of 75% of the states. There have been thousands of amendments to the Constitution proposed, only 27 ratified. Amendments, more than any other political outcome in our system, reflect consensus. That's why you're here today, to weigh whether this amendment deserves to clear those extraordinarily high thresholds. Thank you all very much.
Can we switch it to the text? Yeah. All right. So this wall of text is the constitutional amendment that we're going to be debating. I'm going to be advocating for changing the Constitution to apply term limits to the Supreme Court. This is an argument for democratic accountability. There's not a single other position in our federal system that has lifetime tenure. We waged a war to free ourselves from monarchies, but we have judicial monarchies, right? They serve for life based on hereditary and life circumstances. The founders may have been guided by this idea of judicial independence. If you believe that that is still the case, also Santa Claus is not real. We should think about situating our court into our political system based on reality. The judges are not mythical, magical beings that commune with the Constitution to derive meaning. They're partisans in robes. We should treat them as such. For those of you that go on to law school, the idea that will haunt you when you take properties, this idea is the rule against perpetuities. This idea that the dead hand of the law, you can't craft a document or a contract to govern how people will use that property for 20-something years after your death in order to prevent you from kind of extending your control long after you're dead. This amendment would change it so the president cannot do the same thing to the court any longer. Currently, the system exists in a way that incentivizes the president to pick the youngest person possible who will survive a Supreme Court confirmation battle. That means that if somebody today is nominated to the court and they serve, right, at they're 50 years old, the average, right, appointment of age, if they serve for as long as Clarence Thomas, they would serve for the next 30, how many years is this? 34 years. Where will you be in 34 years? You'll be nearing 40, 50 years old, and that person will still be sitting on the Supreme Court deciding what the Constitution means for all of us. We have no other means of accountability. We might say we can impeach them. That is not going to happen, right? They might face political pressure and scolding, but they're there for life. And that's not a great way to run a representative democracy, right? This system, as we've proposed it here, would ensure a orderly transition every 18 years. Presidents would have a staggered set of appointments so that if you win the presidency, you get to set some people on the Supreme Court. If you win the presidency again, you get to set more people on the Supreme Court. But it removes the lottery of birth and death where random people, right, they might get on the bench because guess what? A bunch of people died and decided they wanted to leave at that time. Those people will stay on there for 30, 40 years. Ketanji Brown Jackson is the most recent nominee. She took her seat at 51. She serves a relaxed life. The average life expectancy right now is 78. Let's say she serves for the rest of that time. She would be serving for another 27 years. That's still outlandish. No part of our system allows someone with unaccountable checks and power on the rest of us to serve for that long. The judges are unaccountable wizard robes, right? They decide what the Constitution means and we are bound by it. We don't really have any recourse. They're the final end of the road. This proposal would ensure that those people who are going to make those decisions rotate through. They can go back, they can be appointed to lower courts, serve down the chain, but it ends after 18 years, right? It allows us to have a system that's going to evolve, allow the Constitution, as we said at the start, to interpret and evolve over time, as we've done through amendments, as we've done through interpretations and how we've interpreted different statutes. The First Amendment means something different today than it did 250 years ago. We should update the justices along with that process. There is no reason why we shouldn't have term limits on the Supreme Court. Yes, term limits for legislative branches have problems. It's one of the very few things, if you're my US government, political scientists, we all agree upon. They're actually not great for legislatures. This is different. The concerns about the term limits for legislatures don't apply to justices. They're removed from the political process. We don't have to worry about lobbyists affecting them or learning, right, how to kind of manipulate that process. We don't have to worry about perverse incentives. Rather, this removes the perverse incentives to nominate a 20-year-old to the Supreme Court. There are no requirements. Every single one of you is technically qualified to serve on the Supreme Court for the rest of your life right now. That's not great. And so how we have it structured here would allow for that democratic accountability. We shouldn't be ruled by the dead hand of a president that gets to pick 40-year-old to serve on the Supreme Court and then dies. And 30 years later, we're still living with their decisions. No other part of our system functions that way. We've changed legislatures to be more accountable. We should shift the Supreme Court to enable democratic accountability. We've strove towards greater democratic accountability in our system. This is the last vestige of an undemocratic process. I yield my time. Thank you.
I understand why a lot of people support term limits, both in Congress and for the Supreme Court. It's fair. It prevents extremely long tenures in office. I'm glad Dr. Morgan mentioned Justice Clarence Thomas because I was going to mention him myself. He was sworn into the Supreme Court in September of 1991, and in September of 1991, I was starting my sophomore year in college. So I was one of y'all, your end of an auditorium like this. They guarantee turnovers. But let me remind you of one thing. Life tenure is not an accident. It is not an unintended consequence. The framers designed life tenure specifically to safeguard the court's independence and to protect our system from political abuse. I'm going to make just two arguments for you this afternoon: that leaving retirement up to the justices themselves is a safeguard against a corrupt or a reckless president, and that term limits might encourage more partisan behavior from justices and not less, which is of course the actual opposite of what the amendment is intended to produce. So let me say that that unpredictable retirement is part of our checks and balances system. The timing of a justice's retirement, or the refusal to retire, is a feature, not a bug. That unpredictability is itself a check against presidential power. Article 3's good behavior clause was meant to insulate justices from politics, but also insulate them from presidents. A justice can refuse to retire if she feels the president is corrupt or the president is reckless. Nominating justices is a presidential power, but it is not a right. There is no right to select justices to serve on the Supreme Court, and a corrupt president or a reckless president does not deserve to nominate a Supreme Court justice, let alone two. No president can count on vacancies during their term. That kind of keeps the court from becoming yet another political prize. The president nominates thousands of people to incredibly powerful positions: ambassadors, members of the central bank, the heads of all federal agencies. Giving every president the power to stock the federal government with his or her own hand-picked nominees is maybe something that we should go gingerly towards increasing. If you guarantee every president two picks, you guarantee every president, the good as well as the bad, more power over the Supreme Court than they already have. My second argument is that these term limits won't depoliticize the court. They'll make it even more partisan. Every justice would start their term in office with an 18-year clock running, and they would have an incentive to get off to as strong a start as possible, as quickly as possible. Right? Now, justices often spend years or even decades building consensus, developing some expertise, carving out a niche. With 18 years in office, they will have an incentive to hit the ground running. Knowing their term's end date from the very beginning will give these justices an incentive to make their mark quickly, instead of maybe choosing to wait on the sidelines a little bit or kind of build a bit of a portfolio. If you already feel like our presidential elections are a nightmare that never begin nor end, think gingerly about adding 2 Supreme Court nominees to every single presidential election. Every presidential election will have the court more woven into the election process than it already is. Now, it's often asked, well, what will happen if this person's elected? From now on, with this amendment, we will know that president will have 2 picks in their first term and 2 picks in a second term. That'll make the court more political and not less. And last, this life tenure allows ideological drift. There are plenty of presidents, I think, who went on to regret their picks to the Supreme Court. President Bush had David Souter, who over the course of his tenure became more and more moderate. Harry Blackmun went in the opposite direction. Right? Life tenure gives the justices the opportunity to develop their own judicial philosophy and not feel beholden and not feel pressure to strike sort of more ideological positions. That's a healthy thing, and I would submit that's a good thing. So in conclusion, let me make 3 comments. Life tenure keeps the justices of the Supreme Court somewhat independent. Unpredictable retirements are a check on presidential power, and term limits would politicize the court even more than it is. Life tenure is not part of the problem, it is part of the solution. It is a constitutional safeguard against presidents who would try to bend the court to their will. If you value the court's independence, however much of that there is, we should avoid reforms that tie it more closely to partisan politics. Thank you all very much. I envy you your chance to make history today. Thank you.
All right, thank you, Dr. Zarmeda and Morgan, for your arguments. You now have heard both sides, the for and the against argument for the amendments that's on the table. You now have a chance to, we've set aside about 15 minutes, although we can go longer because we're running a little ahead of schedule, which is great. We've set some time aside for you to ask questions or clarifications to one or both of our presenters. This is also an opportunity for you to make comments or stake out your own argument or claim, speaking either in favor or against the argument. You also have the text, I believe, in front of you, the detailed text. It's also up on the board here. You can see there's quite a bit packed into the amendments. I think there's a summary on the back of the handout you have as well. So why don't we give you a little bit of time to just find your footing. You can talk to the delegates sitting around you, and then we have a microphone we can hand out for questions, comments, or additional arguments you would like to make. All right. I feel like there's good energy in the room, which is great. Let's begin with questions from the delegation floor. Any questions you have or clarifications, we can ask both speakers to come up and clarify a point if you'd like them to clarify their logic, their argument. If you have specific questions about the text, we can address these as well. And we have a microphone, so. Yeah, let's do that.
This one's more for Morgan. Why didn't you shoot for adding an age limit like we do in the other articles?
That's a very good question. We'll collect 3 at a time, I think.
Hi, Dr. Morgan. So my question is, do you think that adding term limits would encourage potential Supreme Court justices to start campaigning to the public a little bit more?
Very good. Very good question. Anybody else?
I have a question, I guess, for both. Would you consider having a certain amount of justices, and with the senior justice status, will there be a limit about how many we can have? Because currently we have 9, but we can add more justices because there's no set limit right now.
Okay, maybe let's take those 3 and
Okay, so the first question was why no lower limit? I think there's a practical check on that we don't need to. Presumably, the president is not going to nominate a 20-year-old to the Supreme Court, but if you have a 20-year-old that can survive that confirmation process, go for it. actually putting qualifications on the Supreme Court besides our pets are qualified for it. Yeah, I mean, that might be, we could think about, right, like we could improve this institution where there's some requirements for the job. Yep. Yeah, absolutely. I think this would ensure that you could nominate someone who is older. Right now, the incentive is to nominate as young as possible. With this, you can nominate somebody who's 60 years old, they serve for 18 years, 78, they retire off the court, and there would be an encouragement picking the most qualified person rather than the youngest. The other one is increased campaigning, maybe. I don't think that's bad. I think it would look similar to what we have right now. Right now, nominees who are someone who wants to get on the Supreme Court has to signal to a president, but you can't overtly signal. You have to write enough law review articles and make enough decisions on lower courts that you get attention without being a firebrand or bombastic. And it would probably look similar to that. And I think shining daylight on that process wouldn't be bad. So that, yes, the president's going to have to engage with this, the public's going to have to engage with it, and we should. It's the Constitution. It's the law that we're going to have to live under, and so transparency and sunlight, probably a good thing on that, even if, yeah, campaigning's kind of ugly and kind of sucks. But I think we benefit from that in the long run. And then the last one is increasing the number. I mean, I would have added, right, 20 members to the Supreme Court and doubled size. Why not? But I think we could add more to it, and the senior number wouldn't be capped. It would just be however many there are at the time, based on if they're alive or dead at the time. So.
I just want to make one follow-up, and it's really kind of a more political one than a substantive one. So it's kind of funny that this came up because I've been reading a book about judicial elections, and it's really kind of taken me into the weeds of state constitutional conventions. And one of the things that's kind of clear is that if Congress called a constitutional convention, which is what we're pretending to do today, nobody has any idea if there's any limits on what that convention could do or how it could do it. And so, you know, I mean, as to the question of like why we didn't set an age minimum, you know, honestly, Cody, we just kind of set our minds to this, right? Right? This was the thing that we decided to do, and we didn't kind of go beyond the four corners of that. But if this were a real Article 5 convention, you folks could write one and pass one. You could make that, you know, you could set an age limit. You could increase the size of the court to 76. You conceivably could do whatever you, nobody knows what would happen if this Pandora's box were open in real life, which is kind of fun.
All right, these were excellent questions. So let's see if we can get another round of them from the delegate floor. Any questions or clarifications you have? We'll make some room for comments. You can make your own arguments in a little bit, but let's stay in the realm of questions for now.
So I just have a general question for both sides. Can we just get clarification on the regular vacancies? Because you have that presidents would choose 2 candidates each time, but we have no cap on how many. Like justices in total?
I guess 9? 9, yeah, it's 9 unless Congress changes it.
So how would we have a president choosing 2 justices each term, if that makes sense?
4 and 4 years. And you have an 18-year limit.
No, not every year. It's every
2-year cycle off the justice, right?
yes.
Yeah, so every 2 years, right?
Replace under the
Yeah.
year. Yeah. Yeah.
I guess my question is, how would you choose like which justice, like Supreme Court judge would go? Like, yeah, would go first, basically.
So one of the things is that we wouldn't be able to, because of the Constitution, apply this to the sitting justices. It would be as they die or retire, they would be replaced with a new judge who would serve for 18 years. So it would be based on death and retirement of the existing justices, and then the cycle would kind of continue from that. So you're replacing those individuals every 18 years after the current
Yeah, she's had her hand up.
She's probably the only person that's not like doing poli-sci in this
I'm
entire
not.
room.
I'm a nursing major. I don't know anything about this, but so I don't think that there's any kind of vetting process like legally in place right now for Supreme Court justices. Would this be a good opportunity to implement one, like a prior service requirement?
Any,
So for the, it'd be a good opportunity for looking through requirements and what eligibility criteria there is. Like we're saying, we designed around the term limits idea, but we could think about, right, what requirements you would want. Maybe you actually have to have a law degree. Maybe you should have been a judge before this. We can kind of think through those things. We're going to, right, advocate for this as a constitutional amendment, but probably some requirements on how these people. So this question was on compensating them. What's the compensation? Figure out compensation, or is it just?
They must be entitled to like federal pension.
Yeah, federal pension. They probably whatever they're making right now.
Stipend.
Yeah, stipend. We keep them comfortable.
Okay.
They're going to be on a speaking tour making lots of money anyway, so they should be fine. Yeah.
What I said this morning, it's like 300,000 for the Supreme Court judge right now?
yeah, something like that.
I have a question. Are there any concerns about maybe, I guess, a pseudo-monopolization of the court? Like, say, you have a singular party that holds the presidency for 3 or even more terms, and then they end up getting with the Supreme Court that's almost unanimously on their side. Are there any concerns about that?
The concern would be the same as we currently have, right? If you control the presidency for 12 years, likely it's for, or you could control the presidency for 1 term, right? Trump has a third of the Supreme Court he's elected. Yes, that's a risk, but this would regularize it in a way that would minimize the danger there, right? If you want 3 presidencies, you aren't going to get picked a lot of the Supreme Court. Versus right now, well, what the life and death is how we decide if you control for 12 years, right? Well, 1 term, you might go with that Supreme Court. So it would normalize that monopolistic control.
All right, we can still field questions, but we'll also open the floor for comments and arguments that you might want to add to the debate. So now would be the chance to speak out, to tell us that you think you're the delegate here, right? Your role is also to potentially persuade your fellow delegates, right? You want to build momentum behind your preferred outcome. So this is a good opportunity to speak up in favor or against the argument, maybe give your reasoning, why you were convinced by one of the arguments, or why you're still not convinced that it would be a good idea to do that. Let's see if we can get you a little more involved as delegates.
Who wants to make a statement here? Who wants to make an argument? Oh. Okay.
It looked like you were raising your hand, but maybe you were just...
Against? Okay.
Well, I'm in favor of the term limits, because a lot of times that would give opportunity for fresh perspective and fresh blood to be in the Supreme Court, so it won't be as stagnant like it is now.
I'm also in favor of the age term limits, just because I feel like it gives opportunity for like new values of the current generation Because I feel like right now, like courts have like freezed in one area's ideology. If that makes sense.
I'm getting my steps in today. This is great.
Okay, this is kind of like a question. Will you think that an age limit will be better than a term limit? Yeah, because like you said, the term limits will make the Supreme Court more partisan.
So, discrimination based on age is illegal. So, I mean, that might or might not be a good idea, but telling somebody that they have to retire because they have hit a certain age is pretty constitutionally dubious under current law.
I mean, states have, again, for retirement, maybe we talked about that. I mean, the age requirements right now would be age discrimination against it. Right, like, we discriminate against everybody for me, not for Congress. I'm sorry. So, it might survive.
Yeah, I don't know.
But it'd be framed differently because it is a upper end, not a lower end.
I don't know. I mean, it is a protected class.
They would be the ones deciding it, so it probably is going to be unconstitutional.
Well, there is that too.
All right, anybody else? We've heard a lot of arguments in favor of the amendment. Does anybody want to argue against the amendment? Come on, Todd, you want to?
I suppose the only concern that I guess anybody could ever have is while the Supreme Court has had its problems today and times in the past, I would say generally the Supreme Court has been an ever-present march towards progress. I guess some people might get worried that it's like the system, I guess it could operate maybe, it could be minimally better, but people would be worried about like overturning such a significant system, just completely reworking the whole thing for fear of damaging what is already set in place. That's the only thing.
All right. Okay, here we go.
Dr. Morgan, I don't think you have me completely sold yet. So to add to that, I think that there's a lot of positions in our government that we elect based on current perspectives, and so an element of tradition is kind of nice. What do you think?
I mean, you guys know, those of you know me know, right? Like, the threat of destroying the Supreme Court and, right, like, upending tradition, I'm fine with that. But I think it would be good. I think that the idea of the Supreme Court's been kind of the beacon of progress. It is true. It gave us Dred Scott. It gave us Plessy versus Ferguson. It gave us Korematsu. It's not been great. It's been deferential to pretty abusive practices. And so maybe we should revisit those kind of ideas of those things. So the idea that this would upend tradition, yeah, it would. But I think that's good. I think, as we said earlier, the founders designed a system that has laws. And you can think about everything those things better going forward. And if this isn't the way to do it, you try again. You fix it another time too. This would set the precedent for a evolving government rather than one that's stagnant and kind of stuck in the past. So, your concern, I agree, but I think it's a good thing.
I don't know that tradition for its own sake has a ton of value, but I do tend to fear unintended consequences. So I think it's kind of just a different spin on the idea of tradition. And I would also say, and my speech kind of has some of the things I've heard me say this before, Congress could fix the law. Right? Congress doesn't have to let 5 out of 9 justices run the country. Right? And so, there are, solutions within the framework of the system that are really there for the taking. All right, anybody else?
So if you look at when the Constitution was written, most people died very early on, so they didn't want to set term limits because of alcoholic problems, because the water was not sanitary at the time. So they didn't think of term limits, and they might have thought of having term limits later on, especially as you saw the evolution of presidential term limits, because people were living longer and we need to evolve with the times.
Anybody else?
I just have a few points of clarification. So between Section 1 and Section 5, Section 5 states that one vacancy on the Supreme Court shall occur the first year and third year of a presidential term, yet Section 1 states that each term of a justice is 18 years. Could I ask? I'm curious. I don't.
So the person who's nominated in year one of the president's term would serve for 18 years, and then whoever's president at that time would get to replace them in year one of their term, or whenever it falls within that president's term.
Okay, thank you. And then another question. So what's the argument for like the clear politicization of the Supreme Court here then? Because if presidents are nominating and being confirmed by the Congress on a more regular basis, then contrary to the more traditional politicization that we have now that dredges on for years and years, it's just a more recurring politicization.
It would recognize that polarization. It's there. The court's political, and instead of trying to pretend it's mythological, or like it's nonpartisan, they can use the Constitution to ride me. Now there are politicians in robes, and lean into them, right? Recognize kind of who they are rather than pretend that they're not political. So yes, it would politicize the court. Good. That could be more interesting. Yeah.
But they are very fancy robes, very fancy robes.
We're going to be closing the floor soon for debate, so now's your chance. If you want to speak out or against, get your hand up.
Would this open up the floor to having term limits in the Senate and in the House of Reps?
Oh, this is a touchy subject for political scientists. Okay. Like Dr. Limke said, we're about to close the floor. Does anybody have any final thoughts? All right.
Shall we move into a voting procedure then? Okay, all right. If you take out your handheld smartphone devices and if you scan the QR code in the top left-hand corner, you should receive a choice to vote yay or nay on the amendment. We have maybe roughly 60 people in here, so we're looking at, we'll take about 30 plus some votes to make this happen. And we're still getting new votes in, so keep going. All right. Anybody still deciding, or should we reveal the results? Are you ready? All right, let's hope this works. That looks like a simple majority to me, so the amendment is adopted. Do you want to? Yeah, I actually had a follow-up question, and I was curious because we heard this from some of you. Probably relatively unrealistic that we get something like this to happen over in the near future. But there's a lot of buzz around the Supreme Court being polarized, not working. People are unhappy with what's going on. So maybe, Dr. Morgan, you could speak a little bit to what more realistic reform projects do you see? What could Congress, what could somebody do if they have enough votes to maybe push us into the direction of court reform in the next 4, 5, 6 years?
So I think there's kind of two things I could If we have unified government for the next 4 years, I don't think anything changes, right? The current court is 6-3 conservative, right? If Trump's president and Republicans control the House and the Senate, I don't see any reason changing it, right? It's going to kind of fly through. If we see the next presidential election, we see a shift, Democrats start passing legislation, there's some possibility, we have jurisdiction for it. Congress passes a bill, and at the end of it says the Supreme Court cannot review the constitutional status of this bill pursuant to Article 1 powers, and they could kind of just go with that. I think that's more likely. I don't think systemic reform happens. Biden put together a bunch of people to discuss it, and no one on that committee was actually a reform person. They were all opposed to it, and so I don't think there's an appetite for reform, but I could see Democrats feeling pressure to strip the court of jurisdiction if they control the presidency and the House and Senate. But if the Republican majority is next year, no reason to think that they're not going to challenge.
So if anything, an intensification of
Partisan,
checks and balances and struggle over that?
I think it's the intensification of the partisan thing. I mean, the checks and balances are just a political play. It's not reasonable. And so I think we're going to see the court get more political. It's going to be more partisan. The justices are going to bemoan it. They're going to complain. They're going to cry. But they're also going to lean into it at the same time. And Congress is going to treat them as a partisan branch of it.
Thank you for sharing that.
Yeah. Optimistic, rosy outcome.
We're going to close us off here. Thank you guys very much for coming. I just wanted to highlight that next week we'll also be holding an event, Wednesday also, 3 p.m. in Lee Nursing Building. We'll actually be having a talk from former South Carolina Supreme Court Justice from the state Supreme Court, Justice Kay Hearn. She will be talking about the U.S. Constitution, but also about her own experience as a judge in the South Carolina state court system. She was, at the time of her retirement, the longest-serving Supreme Court justice in South Carolina. And so that'll be a really great event. If you guys are interested in the court, that'd be a great event to attend. But thank you very much for coming out today. This was really great. Very good.